Tilburg University and MindLabs present TAISIG Talks, the podcast that keeps you updated on the latest developments in the field of artificial intelligence in just 1 hour.
Welcome to this TAISIG talk. TAISIG is the Tilburg Artificial Intelligence Special Interest Group. My name is Peter Spronk. I'm a professor of computer science. I will be chairing this podcast, but I also have a co-chair, Eamon Taimur. Eamon, can you say something?
Yes, I'm a PhD researcher at TILT, which is the Institute of Law, Technology and Society at the law school. And I'm researching on manipulative AI and generally just the manipulative risks of emerging technology.
Okay, so this talk will be pretty much in your ballpark, because as guest we have Marco Bassini. And Marco, I will ask you to introduce yourself in a moment, but I just want to indicate that we had a TAISIG talk recently, which is probably the one that was published before this one, which was with Tanner Kuru, which was on the legality of data trolling. And we talked a little bit about copyrights in the AI domain. So this is one of the topics that we will delve deeper into today, because this will be a talk on generative AI, human rights, and the innovativeness and competitiveness of companies and countries. Marco.
Hello, thank you for having me here today. My name is Marco Bassini. I'm an assistant professor of fundamental rights and AI at TILT, which is the Tilburg Institute for Law, Technology and Society at the Tilburg Law School. I'm very happy to have the chance to discuss about AI and fundamental rights, especially looking at generative AI, because this is actually what I'm doing in my research right now, focusing in particular on freedom of expression, data protection, copyrights, a lot of fundamental rights of different nature that might be equally affected. And of course, my interest is in understanding how regulators have to react to the challenges that AI systems pose. At the same time, trying sometimes to debunking some narratives, because there are frequently calls for regulation. Every time we see something new in technology, we tend to say, oh, we need new rules, but maybe it's not, a necessary step every time.
Okay. So what challenges are you talking about?
A lot.
Yeah. So tell us about that.
Yeah, we have a lot of challenges. And I would like to highlight the fact that today we talk about generative AI. So we are talking basically about digital artifacts and all the different activities that may be involved and required by creating a digital artifact. So we may see implications for copyright, as you mentioned before, but also in respect of data protection, we may have a lot of issues that I'm pretty sure Tanner Kuru already explored in some way. And also,
sure, but let's assume that people have to listen to that talk.
Yeah. Okay.
Or listen to this a long time ago.
Of course. If we think about the way you can create a digital artifact and you understand, you have more or less an idea of how generative AI systems work, you can understand that, of course, we move from information, which is inputs in a system, which is basically processing content of various nature. Sometimes it's more content, sometimes it's more information and data, sometimes it's personal data, sometimes it's non-personal data, especially for training that system. So to make sure that that system can learn how to make some inferences, for example, learn how to, for example, sum up something on the basis of a longer input, like a text, like 100 pages. Tell me what this text is about. And in one page, maybe you can
summarizing text.
Summarizing, for example, but we can, of course, make up something. Of course, as you know very well now, there is this crazy trend to make cartoons of almost everything. So we can also create different type of outputs. So videos, not only text or images, which is, of course, something that might be challenging for a variety of reasons. As I said before, we have some inputs used for the training in particular, meaning that we input in the training phase data, personal data, something which is governed by a piece of legislation in the EU, for example, the infamous GDPR. But at the same time, we may use copyrighted content. This means that you are using this content or information in a way that, of course, is aimed at make sure that the system can learn something. So you learn how to process tests, you learn how to see something, see patterns, and then to produce an output which is, of course, consistent with the prompt that users may use in the future when that system is deployed. But you can see, of course, that we have a lot of issues also from a legal perspective, because maybe inputting some content or information may create some challenges. One of the most common challenges is regarding, of course, our personal data, because, of course, everyone is concerned about the use of his or her personal data, and people are scared maybe that if you input some information, then in a way, maybe by mistake or maybe by coincidence, a system might output some information which might not even be accurate or no longer up to date. This is a problem which we know as legal scholars as the right to be forgotten, when this may be, of course, a problem we experience in a variety of domains, not only when it comes to generative AI. And if we go back to copyright, for example, once again, if you think about this trend of making cartoons of everything, almost everything, of course, this means that in order for that system to learn a given style, a given creative style maybe, on how to draw, for example, figures, people and objects, of course, there was something that was used in order to make the system learn. And maybe we should reflect on whether this is a use of copyrighted material, for example, something that the law might reserve to copyright holders, which maybe can be licensed by the copyright holders to others. I give you the right to use my copyright contents in exchange for consideration. So I can monetize the creative efforts. So you can use my works, but at least I get remuneration. Here, the concerns surrounding copyright are particularly in light of the fact that we don't know if this is properly, from a legal perspective, a use. So is it just taking a photo sometimes, or even a text, which might be copyrighted as a book, for example, or paper? Is this use? Because, of course, we know that generative AI systems make some connections, make inferences. We know that they are not storing, per se, data or content. This is a point that I want to stress. I was mentioning before the fact that there is in the training phase, we have the use of copyrighted content maybe, or personal or non-personal data. But, of course, we are not expecting the systems to store, but we are expecting the system to learn from pictures, images, data, text, input of various nature. They learn that, for example, I don't know, a given author at a specific style in writing style. And so maybe if you ask a system like ChatGPT, how will you make a text of written by a given author based on the fact that you know that author has a certain style, then the output might be consistent with what the system learned about the author and all the books, for example, papers that he wrote. So this is just an example to say that we need to make sure, of course, that especially in the training of these systems, we are compliant with the law, which is a very important challenge. But this is not the only source of challenges, and these are not the only challenges that we can see, because we have a lot of challenges, of course, concerning AI. We are focusing now on generative AI, so as I said before, digital artifacts. Of course, we may wonder whether producing a given output, like, for example, a cartoon, may constitute copyright infringement, not because of the fact that in the training of that system, of the underlying algorithm, let's say, in simpler words, there was a use of a given content, but rather because the content is very similar to the original one. And similarly, when it comes to output including or containing personal data, we may wonder whether this is legal. Why there is a given output including personal information? Maybe, as I said before, the information is no longer up to date, or maybe the information is wrong, inaccurate, illegal sometimes. which might be something defamatory. And this is another problem that I want to highlight, the problem of the black box. We don't know exactly how they get to that output, and therefore we cannot, let's say, get back to the reasoning. We can't properly speak of reasoning, of course, when it comes to AI systems, but at least we don't know why certain output result from prompts used by the users or by the input that the system receives. So we need to understand sometimes something which it's difficult to understand indeed. And this gives rise to other problems like the problem of liability. If ChatGPT, for example, returns something defamatory, if you ask ChatGPT, who is Marco Bassini, and the answer provided by ChatGPT is that Marco Bassini has a very important and serious record of criminal activities, of course, this is false, this is defamatory, and of course we need to make sure how we can seek, in a way, legal redress. We can make sure that this not only is giving rise to legal remedies and that legal remedies can be enforced, but also we avoid those kind of outputs, which of course are really bad.
Can I interrupt for a moment? Because you mentioned now a whole list of challenges, and they are not all treated in the same way. For instance, the generation of material that is incorrect. And actually, that's fairly easy. If you tell ChatGPT, tell me about when Peter Sprong got in a fight with Marco Bassini, then he will start telling you about that. And we meet each other for the first time now, so we are not fighting. So but that is something that you can say, is that the fault of the AI? Probably that I would say, no, that's the fault of the person who publishes it and shouldn't publish it because an AI can generate lies. We all know that. Well, let's say the copyright issue, that might be a problem of the AI, and the black box issue is yet another issue. So I don't know which one we should talk about first.
Maybe I can start with one problem. So you mentioned a very interesting example of how people are recently, everyone's on this trend of generating cartoon versions of themselves. And from what I recall, there was a specific issue because the most popular style is the Studio Ghibli style that everyone's using. And the owner and basically the person who came up with Studio Ghibli, Hayao Miyazaki, he is very much against AI, but his work is obviously it's open source, everyone can access it, and obviously models have been trained on it by now, and they can generate art in his style. So how do you see art, the future of art in this scenario? Because I feel like it's a very difficult situation for artists and people who are in creative fields, because AI is not just stealing work, but also producing work in a way that it makes the situation quite dangerous for them. They no longer have full control over their whatever they're producing. So how do you see the future?
Yep, this is a very hot topic, let's say, and this makes me reminding a very interesting judgment of the Supreme Court of the US. I don't want to be too much technical from a legal perspective, but I remember that there were some judgments where the court tried to highlight the point that copyright is the engine of free speech, meaning that if you manage to give authors certain rights, and these rights can be monetized, of course, this will be an incentive, a strong incentive for creativity. So you see a very important connection here. In the absence of these incentives, of course, nobody will be inclined to make any creative efforts because, of course, there is no incentive at all. I'm moving from this point because I think it's very telling, the example you mentioned recently. The fact that, of course, certain content are used in order to train the models is per se already a problem, as we said before, because we don't know, we are not sure whether, you mentioned the fact that they are open source, so it might not be an issue from a copyright perspective. There might be circumstances under which the use of this content is allowed under law, and so of course, per se, we can't complain about a copyright infringement in that specific training phase, which is, let's say, the input phase. I will call it the input phase. But we said before that we also have an output phase, but I will cover that later. My point is, we are trying to teach the underlying AI models, which is the style, let's say, the drawing style or creative style of Miyazaki you mentioned, or other very important copyright holders here. But the point is, is this something copyrightable per se? Here it's a bit difficult to understand whether the style is something. Of course, style is something that makes some works clearly recognizable, and you say, oh, this is Miyazaki. You look at it and say, oh, this is Picasso. And then, of course, you notice that there are similarities and common patterns in their works. But it's very difficult to understand the extent to which teaching per se AI models the style of Miyazaki or Picasso or whoever might be is per se copyright infringement. You are using content, of course, but to the extent the relevant legal regime may allow for it, maybe this is not copyright infringement. And so we turn to the second problem, the outputs, because you are learning something, you are getting some skills basically on the basis of the processing of this content in the training phase, but then you use the skills in order to produce digital artifacts. And this means that's okay. Then you are producing outputs that might be videos or images or cartoons, very similar, or even a text, very similar to the content. So here we come to the outputs issue. Is this something that constitutes copyright? Are you basically copying and basically mimicking someone who was already the author of a text already or a very famous artist? So the problem of art is really, I think, a very interesting example because it's very difficult to draw some boundaries. It's also difficult to understand what is per se copyrightable in this specific context.
But couldn't you say, but maybe that, so I have very little legal knowledge here, but if Miyazaki has a lot of art produced and you train a network and you don't put this art in, then it cannot produce the art, his style at the output. And wouldn't he then be the owner of an AI that is trained on his images?
So you make the example of a kind of ownership of this. This is another very interesting point. The problem is that if we look at how the systems work, we notice that it's very difficult to say that they are basically copying. They're not doing just copy and paste because they are learning, as I said before, patterns, some elements that make them able to produce given outputs. For example, output resembling Miyazaki works and creative works in particular. So it is always very difficult to argue for a connection between the author. Maybe it's easier that the author is claiming that this is a copyright infringement and, of course, is trying to make sure that from a legal perspective, this system will not result in producing such output. But if you want, this is a very interesting point that I think we can see in a variety of respects, also from a freedom of speech perspective, because we can wonder whether the output produced by an AI system is speech, or maybe it's just, like the chicken voice. What I'm making the silly example of the chicken voice just because we assume that there is a lack of reasoning behind the generation of that content, right? We feel that every time we are interacting with ChatGPT or other systems, they are not aware about the content of the output that we see. And we just know that they can understand more or less which is the most likely word that will follow in a given sequences of words.
I wouldn't use the word understand here, but
yeah.
They know the patterns.
They know the patterns, basically, right? It's not even the words per se, it's the token, technically. But this makes very clear that we can't expect that, let's say, behind the screen, we have an author thinking and trying to provide some meaning behind the words that you can see on the screen. And this is a problem that I see also in the respect of copyright, if you want. So even the creative efforts that Gen AI systems can develop, resulting in the creation of that output or the digital artifacts that we can see right now, can we really see that this is the result of some, let's say, proper authorship? This is what I will say. I think it's very difficult also to determine if someone is the owner. And this is another point that we discuss, especially why I mentioned freedom of speech, because sometimes we wonder, who is the copyright holder in the copyright domain? We feel that this problem may be connected also to free speech because of the possible output that you see in ChatGPT, for example. But how can you make sure that the given output we are considering is the result of what the programmers or the developers of that system wanted to have in response of a given input of the prompt used by a user? It's very difficult to predict what will be, of course, the output. And of course, I think this makes weaker the connection that we could try to build from a legal perspective in terms of authorship. And I'm not speaking here of authorship in strict terms only with respect to copyright, but also with respect to freedom of speech. Can we say that, just to make a very silly and kind of extreme example, ChatGPT developers are responsible for defamatory outputs? Maybe they didn't want ChatGPT to say something offensive or defamatory. But in the end, if that result is what we can see and consider defamatory, of course, that's a problem, of course. And I made the silly example of the chicken voice before just to say that this is a problem of understanding, of course, whether this is the result of reasoning. But there is also, I think, a huge problem of making sure that this is what developers wanted the system to produce. You know that machine learning techniques make it possible for the systems even to go further, go beyond, let's say, because they learn. And the fact that there is learning activities, I think, will create a possible divergence between the input the systems receive from the programmers, from the developers, and the output they generate.
Yeah, in principle, I don't think the developers can do anything about that because there is no understanding in an AI system. So what you see is it's trained. And if you do ChatGPT as an example, it's trained on a large language. There's a large language model underneath, and the large language model can generate anything you want. It can generate racist talk, etc. And then they put a GPT on top of that, so that that's those kind of things that you don't want the system to produce are not produced. Well, are a lot less likely to produce because you can still get them out, but it's a lot harder. So I don't see that is a tool that they have tried to protect against certain things, but the protection can only go to a certain area. Yeah. And from that point on, I would say the responsibility lies by the person who's publishing it. Seems logical to me.
What do you mean by the person?
Well,
who's publishing?
if I ask ChatGPT to produce a text and I try to get it to produce something that is defamatory, for instance, then and I say, okay, I have this now, and now I put it on the internet, and I say, yeah, it's not my responsibility. This came out of ChatGPT. Sure. Then I would say I am responsible for doing that.
I think it would make more sense if you kind of move away from the example of a large language model like ChatGPT. We can talk about deepfakes, for example, like the technology. It's also a version of Gen AI. And I mean, deepfakes are produced by these programs that are available online for anyone to access. And I mean, if someone does use that technology, does that implicate them, or is it the developer in that sense then? I mean, that's also a question, right?
I think it's the same example, basically.
Yeah, I think you are touching upon the right point here, which is depending on the way we use the systems, there might be consequences. And of course, I don't think that the fact that this technology is so much disruptive, this will change a lot of things. If we are using, for instance, creating deepfakes, these systems for something illegal, we know that there is a huge problem with pornography deepfakes. So of course, something which is relevant also from a criminal law perspective. This is a crime in the offline world, in the real life, and this should remain a crime also when the way that deepfake is produced, that the result is generated, is through the use of Gen AI systems. So I think that's, in that respect, I don't see many challenges to claim some responsibility and liability for the creator of that content, because I don't see, if you use that system and deliberately provide instructions to that system to create a digital artifact with certain characteristics and feature, provided that the system can do so, because sometimes now you experience some restrictions, some constraints, which is good also for protecting maybe individuals, because sometimes this isn't I see the picture of a real person there, so I can't process this result. I can make a cartoon maybe, but I can't process the real image of that person. But just to say, in this case, I see, okay, you provided instructions deliberately in order for the system to generate that output. I see a different problem when we are looking for information on ChatGPT about an individual, for example, or maybe about some historically debated and controversial facts. And the output generated by ChatGPT is something which might be totally made up, or maybe inaccurate, or as I said before, it contains not up-to-date information about individuals. So in that case, of course, it's very difficult to understand who is the owner of that output. And I see this problem in a partially different way from the problem of copyright, where so far we don't have any judgments, at least to my knowledge, affirming that you can have, let's say, Gen AI as copyright holder. So we can't expect that copyright is attributed to the developer of an AI system, but we may see these developments maybe in the future. With respect to freedom of speech, I think it's a bit different because of the concept of authorship as a different value compared to copyright. And here the point is, okay, let's assume that that sequence of words or tokens, as we said before, makes sense. So there is a meaning. And the meaning is offensive to one's reputation, so it's something defamatory. How can we, and maybe we don't have a user that deliberately asks ChatGPT to make up something defamatory about an individual, or to tell a specific version of quite controversial historical facts. We have just a kind of neutral request, a prompt that you are using, and the answer is something inaccurate. And this is, I think, the problem that we have to consider in connection to another point that I am trying to address in my research right now, which is the problem of understanding if we consider freedom of speech involved here, we need to face also the consequence of that in terms of content moderation. What I mean by that, just to be clear also for legal experts, we can expect maybe that developers and providers of AI systems can do something in order to prevent certain results from being displayed. So you can maybe make sure that you are not interfering with the way some output are produced if there is nothing illegal, but maybe when it comes to some type of content, you can prevent it. I made the example before of the processing of real images of living persons. What if the system is deliberately programmed in order not to produce certain outputs? Is this censorship? Can we consider this to amount to censorship? Because from a general perspective, we may say, oh, it's good that you are teaching ChatGPT not to produce some output because it is not good that people rely on the information generated by such a system because maybe this information is inaccurate. But on the other hand, how we draw a line between what is just a technical setting of the system, and this is something good. If we recall TAISIG and code is law, the idea that you can do something from a technical perspective to avoid legal consequences also as a source of regulation in legal terms, it's perfectly fine. But at the same time, you are interfering in a way with the ability of the system to produce some results. Just thinking about the consequences that may see in the domain of political propaganda. What if one of these companies developing Gen AI systems decide not to let this system speak about politics in a specific way? So giving rise to viewpoint discrimination. You can't be critical of the current majority, of the current government. This is from a perspective of the protection of democracy, to touch another aspect which I think is very connected with fundamental rights and rule of law. is very important, because then if people use ChatGPT to get information, to get knowledge, the distribution of information will be uneven, and I don't want to say that they will have some biases, but they will become politically biased in the end.
I've come across research on this quite recently where they saw the responses that ChatGPT was producing for different kinds of questions. So they asked questions about Biden and then they asked questions about Trump. And ChatGPT was showing a very clear bias towards libertarian values, and it was very much left-wing in its answers. So do you think at this point neutrality might be a myth altogether, because data sets are not, they can never really be truly neutral in the truest sense?
Yeah, here we have an intersection, I think, of different layers, which are absolutely key to the development of AI systems in a law-compliant way. Because on one hand, you mentioned data, and of course the fact that the more data on which AI models are trained are accurate, the better. And this is also a requirement we can now see in the EU AI Act. So it's very important that we stress that. But of course, data, I think, are always partial and a limited amount. So depending on the data sets you have and you're using, of course, the output may be, of course, better or worse. So it's not easy to make sure that we use some inputs, and of course we can expect that the system is not going beyond that input. So if we use a biased data set because it just partially represents what happens in society, and maybe there is just limited data concerning underrepresented minorities or some vulnerable groups, of course the result might be, and this is a huge problem we are facing now in AI governance, generally speaking. But at the same time, this is very I think it's very important at the intersection of freedom of speech is a point to consider in that respect, because it's clearly, they generally say you are what you eat, right? And I see some problem here when it comes to freedom of speech in using this assumption, because it is true that there is reliance on training data sets. But at the same time, we know that people expect to use ChatGPT as a source for information. So every time we interfere with the ability of these systems to produce some output, we should wonder whether this gives rise to viewpoint discrimination. So, and maybe we want to have a more balanced and pluralistic overview of content, which is per se one of the purposes that law may accommodate, and it's definitely relevant from a constitutional perspective as well, because we want to have a diverse set of information. But how we can make that without, it's very difficult to make sure that, and this is also one of the problems of the use of AI in the context of media.
Can I ask something? Because you've been using the term freedom of speech now for the last 10 minutes or so. So whose freedom of speech are you talking about? Is it the freedom of speech of the AI, of the person using the AI?
I think this is a very key question. So far, only American scholars have focused on this problem, and just a few European scholars, but I haven't seen a lot of research on this yet. And I can tell you that most of these scholars see the problem not from the perspective of the speaker, but from the perspective of the listener. So the receptor of information. Why? Because of course we have, first of all, a problem of authorship, which is connected to what we said earlier, and the fact that we don't know if there is a, let's say, a owner for that speech, provided that it is speech, because this is another point we need to address. But it's very difficult to say, oh, this is ChatGPT speech, or maybe it's the user speech because the user asked ChatGPT to create outputs based on such instructions. I will see the problem, as these scholars try to do, looking at the problem of the interference with the right of people to receive information without constraints, without unreasonable constraints, I will say. So if you take the example that I made before, if a government passes a law in order to prohibit ChatGPT or other Gen AI systems to be critical of it, this is a huge interference with the ability of individuals to to get this information. And this is something unreasonable because maybe we can see some restriction also content-based sometimes. If we want to avoid ChatGPT to say something defamatory, governments can pass laws. I don't think it's necessary because we already have laws against defamation, for example. But if we want to strengthen the protection of individuals against the risk of seeing their reputation harmed by the system, fine. Let's pass a law where a government can prohibit ChatGPT to tell something defamatory. But the problem is that defamation is something harmful for some specific legal interest, which is reputation. It's a content-based restriction, yeah. But is this a viewpoint discrimination? This is the view that American scholars take. It's not a viewpoint discrimination. It's just saying that you can't say anything harming the reputation of an individual. So if we just ask ChatGPT not to return output critical of those holding the power, this is viewpoint discrimination. So it's you see the difference. And I think that from a societal perspective, we can understand that governments are trying to suppress, in a way, or censor these systems not to produce defamatory content. It is an enforcement of existing laws, so I wouldn't see this as a problem. And likewise, I wouldn't see this as a problem if universities or governments were prohibiting, for example, students from using ChatGPT. I wouldn't agree. I will not be sympathetic to that kind of restriction, but I will understand that you say we can't allow students to use ChatGPT because for their exams, for example, or for other assignments, because that will be a content neutral. You're not prohibiting ChatGPT for some contents just because you feel that it's not good. Students use ChatGPT during their educational path. And in this case, we don't have any viewpoint discrimination at all. So I wouldn't say we have a speaker here. I don't see a speaker. There are interesting pieces on this point. Apparently, we can just look at the passive side of freedom of expression, which is the freedom of individuals to receive information and at least to think that this is one of the possible sources of information and without any governmental constraint on it.
But okay, so if you translate freedom of speech to, let's say, the ability to receive certain information, I want to receive this kind of information, and if I can't get it, then my freedom of receiving information is restricted. But then that means that, first of all, that AI should be able to generate everything, so you cannot put any restrictions on it. That seems to me a bit of a problem. And also, so I can demand that an AI, for instance, it gives me the so I say I choose to use ChatGPT, and so now the people who create ChatGPT are forced to build into that the things that to allow it to generate the things that I want to hear. And the argument that you gave for that is that people use it as a source of information, and they should be able to get this information.
Yep.
But it's not a source of information.
Yeah, this is another very interesting point, which is maybe the point that I didn't address before, because I said maybe it's whether this is speech, this amounts to speech. Because as I said earlier, maybe it's just a chicken sound or something without any reasoning, without any effort to disseminate meaning. And so we can maybe say, okay, fine, this is not speech. This is an open debate indeed. So apparently, especially in the US, now, freedom of speech is under a lot of pressure for a variety of reasons, but trying to now get rid of the political contingencies. I think we know that the First Amendment has a huge value in shaping the US legal system. If you look at the degree of sensitivity that the US culture has towards freedom of speech, you notice that it's very expensive. It's very it extends to every context of life, almost every context of life. And I feel this is, of course, something that has consequences also in this domain. So I will say that now there is the attempt to say, hey, just be careful when you expect to regulate what AI can say, because we can't exclude that this is also speech. And I see this as a consequence of this attempt to extend protection rather than limit it. But this, if you want, make me return back to the 90s, in particularly to 1997, when the Supreme Court of the United States heard the first case concerning the internet and possible restrictions on the ability of users to find some content on the internet, which is Reno versus ACLU for the legal jigs who are listening to us, where the court said that in the absence of evidence proving the contrary, governmental interference with the free flow of speech, especially on the internet, which was seen as exceptional and unprecedented, is never justified. So it's better not to interfere with freedom of speech than interfere. That is the mindset of US courts and scholars, which is a bit different from the mindset we have in Europe, where you know that the European Union has done something, I will not say maybe a lot, but has put some efforts into the contrast to disinformation. Disinformation is a huge problem also because we are afraid of the possible influence on the political and democratic processes. But at the same time, we see this as a problem because of the different value that freedom of speech is given and generally speaking in European countries, which is, of course, freedom of speech is important, is a fundamental right, but it's one among the different fundamental rights you see in constitutions and European conventions and charters. So when it comes to disinformation, we have a huge problem in distinguishing what is disinformation and just lies, and what is disinformation harming legal interests. So defamation, for example. Defamation is saying something wrong, false about an individual, for example. But defamation is a kind of disinformation, if you want, that harms specific legal interests. So the law can do something in that respect. The law already does something which is prohibiting generally defamation, criminalizing maybe defamation. When it comes to disinformation, that is just a bunch of inaccurate stories, then of course it's more difficult, because then maybe we can expect, I wouldn't say maybe this is covered by freedom of speech, but how can we make something against expressions, opinions, ideas that do not offend any legal interest? I try to make it simple for lawyers, but it's very difficult to distinguish and to draw a clear line between what is what kind of disinformation is illegal and what is not illegal.
So I would like to talk a bit about the competitiveness. What do you think?
Yeah, that's a good idea.
Yeah, so because you were now actually talking about differences between Europe and the United States, and we know that. And you can also look at Asia, for instance, and maybe Africa is going to play a role in that in the future as well, where the laws differ and the laws restrict what is possible, what is allowed, and there's a lot of investigation in that at the moment. But people seem to be very worried that Europe is going to lag behind. And then, for instance, Europe has now that AI initiative, 200 billion euros going to be invested in AI, which is actually relatively small compared to what is invested in, for instance, the United States in AI.
Sure.
So can you discuss that? So what is the effect of competitiveness, innovativeness, where, so should we just go the route of the United States and make everything open, everything is allowed, just out of fear of getting behind?
I think we are already behind in a way. And it's my, jokes aside, I feel that we may have different points to discuss in this respect. Let's move from let's say the starting point is that Europe, and particularly the European Union, has a quite clear understanding of the role of regulation, in particular when it comes to fundamental rights. There is a very nice book by Anu Bradford. There are two books indeed. One is The Brussels Effect, concerning the degree to which Europe, and particularly the European Union, is trying to shape global governance of certain phenomena, extending beyond its territory, EU law. And the other one is more recent, is Digital Empires, especially focusing on the challenges for digital and a driven society, let's say. And she's trying to make a very clear point from the beginning, looking at the fact that Europe is really focused on regulation as a possible response to all these challenges, while there are other paradigms, especially in China and in the US. In some jurisdictions, she mentions the example of China, for example, there is more state control. In other jurisdictions, such as in the United States, there is more a market-driven paradigm, where the concern is that regulation will hamper innovation and competitiveness. So the idea is that before regulating something, you should be very careful and really carefully think about it. And if you think about the example I just recall in the 1997 Supreme Court case, they didn't want to regulate actually restrictions on certain content online, pornography-related content in particular, because of the concerns they had for the constitutional right of adults to have access to this content. Just to tell you how much they are focused on free speech and on the market in the same vein in a way. So the Europe has taken a clear approach. This approach is that you can't have a safe digital economy without safeguarding fundamental rights. I'm not here to say that other jurisdictions disregard fundamental rights, because that would be inaccurate, and I don't think this is the right way to look at the problem. But of course, the reaction of the EU is very clear. We need to regulate. The point is that apparently, if we look at the AI Act, there are many comments by scholars who were supporting this very important legislative initiative, who makes the point that now maybe the AI Act is unlikely to deliver its promises because it's too much bureaucracy. Some of them say that it's not even so protective of fundamental rights. It's more like a product safety piece of legislation, conformity assessments, information requirements, certification systems. Honestly, you get a headache, a very strong one, when you're going through the AI Act. It's a very complex regulation. Of course, we have to welcome it as an important achievement, at least if we live in the EU and we feel that we agree with the approach of the Union. But the problem is that I think we need to think about the companies that are acting in this market and will have to comply with the rules. And these are not only the big techs we are talking about. There are many companies, many startups maybe, that will have to comply with the AI Act, with many provisions that are very burdensome. Sometimes I see something like, we should shut down all the American tech companies in Europe. I don't think this is the way. I think this will lead to unintended consequences. I see the point, because the point is make sure that either we respect fundamental rights or you're out of the market. But this is not the way. I think it's not the political negotiation. It's like we are talking about law. We are talking to make things effective and make sure that that regulatory paradigm can work. And the huge concern that we experience now is that Europe wanted to be the first mover. It was already the first mover when adopted the GDPR for data protection. But I think in the context of the GDPR, there was a kind of competitive advantage for the EU, because it was already a developed market where the EU could say, okay, fine, since you American companies are very interested in targeting European residents, I tell you that you have to respect their fundamental rights to data protection if you want to work in the European market. So there was a kind of clear message. There was also already some case law on this, like the right to be forgotten, so make sure that some companies could comply with EU law. Now we are in a different context, in my view, because Europe doesn't hold any technological leadership. If you try to be honest, I don't think that Europe is even the second, market leader in AI. We don't have any leadership, and I'm wondering whether this approach is consistent. The approach of regulating almost everything, if we look at the AI Act, is consistent with the idea to create conditions that will facilitate the opportunities and compliance at the same time for the companies that want to be respectful of fundamental rights, but at the same time, they don't want to die of bureaucracy. And I just want to touch upon an aspect which I really care about. In the US, when the first digital platforms, the online platforms that were born at the end of the 90s, in 1996, of course, we didn't have the big techs. We didn't have the tech giants that we know now. And of course, there were a lot of small platforms which were basically virtual communities where we could join a community and start in a forum to talk about movies, to talk about soccer or food, whatever. So there were no oligarchs, let's say, or monopolists. But at that time, there was a risk that these communities and these platforms were in charge of content moderation, and particularly there were concerns about the fact that there was too much pressure on them. This is why they pass a very interesting provision, which is now still there and is applicable, which is named Section 230. Section 230 says something very simple, that if you are just a service provider, so you are just the forum hosting third-party speech, you will never be treated as the speaker. Why you can't be treated as the speaker? Not only because sometimes it's impossible for you to carry out content moderation, because if you have thousands of users, it becomes very difficult. But for the simple reason that in the US, they thought it was wrong to make them, let's say, the arbiter of freedom of speech, or what is right, what is wrong. And they didn't want them to engage in content moderation that way. They wanted to leave them free from pressure. So if you don't like that content, it's your house. You can remove the content and you will not face any liability. If you think that content is okay, given the huge protection of free speech, leave the content there. You will not incur consequences. The author of the content, which is maybe defamatory content, will have consequences, will face consequences. The reason why they wanted to do this was avoiding the specter of tort liability, which is a wording taken from a judgment in 1997. Because otherwise, if you face the risk of incurring liability and then maybe being required to pay damages, just to make an example, you will be very inclined to strict content moderation. So you take every content down because you are afraid that, maybe tomorrow someone will sue me and I will go before a court and then they will come after me and I will pay a lot of damage. So the idea, of course, now if we look at this rule and we think about what the big techs do, we think that it's a bit unfair because they have a huge business model, they have a huge market presence, and we look at this rule and say, it's very kind of digital liberalism, someone said. But the reason why this rule was carved out in 1997 was exactly to protect speech. So sometimes and this is the reason why I wanted to put in the connection with what we were talking about before. I think sometimes you look at something and you think it's unreasonable, but we need to think about the reasons why lawmakers decided to take that step. And I think that also in the context of generative AI, maybe some rules are too much, in my view, bureaucratic and strict now, and we don't realize that Europe is not a market leader. So maybe you should facilitate this business, make sure it is consistent with fundamental rights protection, it's accompanied by sufficient safeguards, but we shouldn't, I don't think that if we look at the AI Act, this is very supportive of innovation. And I'm not taking the view, this idea that either you protect fundamental rights or you are basically promoting innovation. I don't think this is Anu Bradford, I mentioned her before, recently wrote a paper where she said this is a wrong choice. A wrong choice in the sense it's a false choice. You shouldn't be able to choose. And I think that, for example, states should not ask their citizens if they prefer fundamental rights or innovation. I don't think you should leave them choose about, so do you want more privacy or do you want more innovation? I don't think this is the way we should move forward. But competitiveness is a problem because companies are not here. And so we are like the recipient of their business model, but it seems that they're pushing them back, maybe. So I'm a bit concerned about this.
Yeah, well, I still have one question then left here is to what extent would we want to have that? I can imagine, for instance, that we say we want our own European AI because, let's say, you mentioned AI has biases and different AIs. Also, if you look at the United States, they have different AIs with different biases. So it seems to be something that people are going to develop their AIs specifically for their perspective. And then it would be logical. But Europe doesn't really need an AI industry to develop their own AIs.
That would be great because that will be for maybe the way forward for gaining more markets. I wouldn't say dominance, but at least presence in a way. But at the same time, I feel that we have some risks when every jurisdiction is trying to build its own AI. It will be like a balkanization. We experienced something similar at the rise of cyberspace. It seems that every country wanted to have its own internet, and governments were trying to make some content available in that country, and so they were trying to cut some deals with big techs to make sure that only the content that governments like could be available. So I see the point of promoting European companies, and I'm connecting to the point I made before about Section 230 CDA. So just try to incentivize companies and startups in particular to and let's try to support them in a virtuous way, of course, in the sense that we have a clear regulatory model in Europe which is protecting fundamental rights, individuals. But I don't think that Europe should look for isolation, because I don't like the idea that, we now build our European AI and then we close all the doors and we look at the American companies or the Chinese company and say goodbye, which is, you see now that we have already some responses from data protection authorities. For example, I come from Italy, and the Italian data protection authority is very sensitive on Gen AI systems. In particular, they, as you know, they blocked ChatGPT 2 years ago, and then they blocked DeepSeek for a while, just to make sure that they could collect information to know the relevant data protection, data processing practices. And it's a possible response. It is not the AI Act here, it's the GDPR, it's data protection law, just to say we value data protection. So either you comply with these rules, or maybe you are out and you can't operate your system within the EU borders. Also, data protection now is a bit under pressure. The EU said that they might want to change something in the GDPR very recently, a few days ago. They announced that there might be some changes to make it easier, especially for smaller companies, to comply, which is something to welcome, I think. But why don't we do something similar for the AI industry? Because I don't think that's, just to say goodbye, everyone. I will develop my AI is something that will be rewarding as an option. And I prefer thinking that people will continue to use different services, and maybe that other systems like ChatGPT or DeepSeek will find a way to comply with European rules in a way. Just not to forget that more players we have, the better should be from a market perspective in a way. So I'm a bit scared about the idea that we build a national AI.
Yeah, on the other hand, I would be scared of the idea that my individual rights are going to be sacrificed because we're afraid that we lose out
Absolutely.
on getting big companies. Is there anything you want to add?
No, I think that this would be a very long conversation between people with technical expertise, lawyers, human rights experts, and I think there is a lot to discuss, even from an economic perspective, for example. A problem we didn't touch upon today, but it's very recurrent now, is sustainability. How we make sure that the operation of these systems is not affecting some environment, generally speaking, and then against the idea of sustainability, which is a very pressing need for our society. So I think there's maybe if we meet again in 1 year, but maybe in 6 months, not only I will change something in my in my views, but and then maybe you have different questions or different opinions. But I think there is a lot we can discuss. Just for saying how much timely was this conversation. The EU legislators were not considering generative AI at the beginning when the European Commission, that is not a legislator per se, but then when the legislative process started, ChatGPT, let me say, OpenAI existed already, but of course the system was not that much popular. It became popular during the legislative process, and then the legislators said, oh my God, this is something we should really care and we should deal with. So just to say, since regulation is always lagging behind, and I'm sorry if I disappoint you, but it's always happening, I think there will be a lot that will come up in the future. So thank you for
Thank you for being here.
Thank you.